A Supreme Court fight over gun carry rules has people screaming that permits are finished. But if you believe that headline without knowing the real case, you could make a very expensive mistake. Quick question before we continue. Are you subscribed? Because this channel breaks down gun law in plain English, and the next legal change you miss might be the one that gets you charged. Hit that button now. Now let me calm this down and make it clear. No, the Supreme Court has not issued a ruling that wipes out every gun permit in America. That part is simply not true. But here is the part that should get your attention. The court has already changed the legal map once, and the next case could change where your permit actually means something. In other words, the old mindset of I have my permit so I'm good is exactly what can get you in trouble. And that is why this story matters so much to you. Here's what just happened and why people are so confused. Back in 2022, the Supreme Court decided a major case called New York State Rifle and Pistol Association versus Bruen. That case struck down New York's old proper cause rule. In simple English, New York used to make regular people prove a special need before they could carry a handgun in public. Saying, I want to protect myself was not enough. You had to show something more unusual, like a specific threat. The Supreme Court said that was unconstitutional. Now, this is where it gets interesting. A lot of people heard that and jumped to a wild conclusion. They acted like the court said permits themselves were dead. That is not what Bruen said. In fact, Justice Brett Kavanaugh wrote separately that many states still use what are called shall issue systems, and those systems can include objective rules like background checks, fingerprinting, training, and mental health record checks. Objective just means the state has a checklist. You either meet it or you do not. No one gets to deny you because they feel like it. So what really changed? The court said states cannot force you to beg for a permit by proving some special reason beyond self-defense. That is very different from saying states can never require a permit at all. Most people miss that difference, and that difference is everything. Think about it like this. Imagine two doors. Door number 1 says, pass a background check, do the training, fill out the forms, and if you qualify, you get the permit. Door number 2 says maybe you qualify, maybe you don't, depending on what the licensing officer thinks about your reason. Bruen slammed door number 2. It did not remove door number 1. That matters because a lot of gun owners hear one viral clip, then start talking like every permit is pointless now. That is how bad legal habits start. That is how someone carries in the wrong place at the wrong time with the wrong assumptions. And when that happens, the prosecutor is not going to care what some social media thumbnail told you. But here's the crazy part. After Bruen, several states did not just shrug and walk away. They rewrote their laws fast. They started saying, fine, maybe we cannot block permits the old way, but we can still control where those permit holders may carry. That is the next battlefield, not always whether you can get the permit, but where that permit actually works when you step outside your front door. If you're finding this helpful, imagine what you'll learn in my next video about the exact mistakes gun owners make during police encounters. Subscribe now so you do not miss it. So let's talk about the case that has everyone fired up now. The big one is Wolford versus Lopez. This case came out of Hawaii. After Bruen, Hawaii passed a law in 2023 that said a person with a concealed carry permit could not bring a handgun onto private property open to the public unless the property owner gave consent. Read that again in plain English. If the place is private property but the public can walk in, the default rule becomes no gun unless the owner says yes. That includes the kind of places people enter every day: stores, restaurants, banks, other businesses open to the public. And according to reporting on the case, violating that Hawaii law could be charged as a misdemeanor punishable by up to a year in prison. So no, this is not some tiny paperwork issue. This is real-world criminal exposure. Now ask yourself this. If you have a valid carry permit and you walk into a business with no sign posted, what do you assume? Most people assume silence means okay, but Hawaii's law flipped that assumption. Under that approach, silence means no unless the owner clearly says yes. That is why this case matters so much. Here's a hypothetical example to explain this. Let's say you stop for gas, then go into a small market to buy water. You have your permit, you pass the training, you are law-abiding. There is no sign on the door. In your mind, you are doing everything right. But under a rule like Hawaii's, that same moment could become a criminal problem because the law treats the property as off-limits unless the owner gave express permission. That is the trap. When the Supreme Court heard arguments in Wolford on January 20th, 2026, reports said several of the justices appeared sympathetic to the gun owners challenging Hawaii's law. The argument was not really about ending permits nationwide. It was about whether a state can make private property open to the public a default no-carry zone, even for licensed people. That is a huge difference. And here is the part nobody is talking about enough. This is also a property rights fight. One side says private owners should control their property, and the state can help protect that choice. The other side says the state cannot rewrite the default rule in a way that singles out the Second Amendment and turns most everyday places into off-limit zones. That is why the questions from the justices got so sharp. And there was even discussion about whether these rules make the Second Amendment a disfavored right. That phrase matters because if courts think a state is treating gun rights like second-class rights, that can change the outcome fast. At the same time, do not overread oral argument. This is where people get reckless. Just because some justices sound skeptical does not mean you have won. Lawyers know this. Viewers often forget it. Tough questions are not a final ruling. Headlines about the justices sounded angry are not legal protection for you in the parking lot of a grocery store. And the ripple effects could go beyond Hawaii. The National Constitution Center also pointed to a similar case out of Maryland, where judges struck down Maryland's ban on carrying on private property open to the public. So if the Supreme Court speaks clearly in Wolford, that ruling could shape how other states write carry restrictions too. Hey, 73% of people watching right now are not subscribed. Do not be part of that group. Join the gun owners who want the facts before the headlines twist them. Click subscribe and stay ahead of the next ruling. Now let me break down the part that confused almost everybody online, the phrase emergency ruling. That phrase sounds dramatic. It sounds like the court dropped a legal bomb overnight. Sometimes that happens, but a lot of the time, an emergency application is not a final decision on the whole case. It is more like someone asking the court to step in immediately before the normal process finishes. Think of it like hitting a legal fire alarm. One side runs to the Supreme Court and says, "We cannot wait. We need relief right now." The court can say yes, no, or say nothing meaningful about the bigger issue yet. That is why emergency docket news gets abused so badly on social media. A perfect example is Antoniuk versus Negrelli from New York. In that fight, the Supreme Court denied an emergency application on January 11th, 2023. That application asked the court to step in while lower court battles over New York's post-Bruen gun law were still going on. But the court did not strike down all permit laws in that action. It denied emergency relief. That is it. Huge difference. Most people hear Supreme Court and stop listening after that, but you cannot do that with gun law. You need to know whether you are looking at a final opinion, a temporary stay, an emergency application, or oral argument. Those are not the same thing. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Here is what most people get wrong. They think if a state loses one argument, the whole carry system disappears. That is not how this usually works. States often lose one tool and then try another. First, it was special need requirements. Then it became long lists of sensitive places. Then it became rules about private property, public transit, parks, healthcare facilities, restaurants that serve alcohol, and more. So the real legal game is often not, can you own a gun? It becomes, where can you carry it? Under what conditions and what default rule applies when the law is silent. And that is why this topic should matter to you even if you already have a permit in your wallet. Let's get practical. What should you do right now? First, do not assume your permit means universal carry. It does not. Not after Bruen, not before Bruen, not now. A permit can be valid and still useless in certain places. Schools, government buildings, and other sensitive places may still be restricted. Even after pro-gun rulings, many location-based limits survive. Second, know the difference between getting a permit and using a permit. Those are two separate legal questions. You may have been lawfully issued a permit and still violate the law by carrying in the wrong place. That is a painful truth, but it is true. Third, read your state's current carry restrictions, like your freedom depends on it, because sometimes it does. Do not rely on a gun store counter story. Do not rely on an old forum post. And please do not rely on your cousin who says, bro, they got rid of that. Maybe they did, maybe they did not. You need current law, not parking lot law school. Fourth, if you travel, be even more careful. One state may honor your permit, another may not. One state may let you carry into many businesses unless posted otherwise. Another may treat private property as off limits unless invited. Same gun, same permit, same person. Totally different legal outcome. Imagine you are on a road trip. You stop for food, then run into a shop, then check into a hotel. 3 simple actions. But if your understanding of the law is based on a clickbait title instead of the actual rule, you may be stacking risk without even knowing it. Fifth, document your caution. If your state uses posted signs, learn what valid signs look like. If you are unsure about a business, Ask. If you are crossing state lines, verify reciprocity before you leave, not after blue lights appear in your mirror. And let me say one more thing. Do not confuse being morally right with being legally safe. A lot of gun owners say, this restriction is unconstitutional, so I am ignoring it. I understand the frustration, but until a court actually blocks that law, enforcement may still happen. You do not want to be the test case unless you are fully ready for the time, money, stress, and risk that comes with it. This information could change the moment the court hands down its next major Second Amendment decision. Subscribe now, because when that ruling drops, I am going to break down exactly what changed, what did not, and what you need to do next. So here's the takeaway. Gun permits are not over, but the old idea that your permit automatically protects you everywhere is falling apart fast. Bruen already changed how states can issue permits, and cases like Wolford show that the next fight is about where permit holders can legally carry once they have one. Do not let a loud headline trick you into a quiet felony or misdemeanor problem. Stay sharp, stay current, and if this video helped you cut through the noise, subscribe right now and share it with one gun owner who still thinks one permit means 50 state safety. Final simple disclaimer, laws change, facts matter, and your state may be different, so always check current local law or talk to a qualified attorney before you carry.